Okay, first of all, this is my first of all, I want to confirm with everyone. Can everyone see my screen? Okay, nice. Okay, so the today's session, the reason why I allocated it into 2.5 hours is because the chapters we are going to cover will be quite bulky and lengthy as well. So that I have purposely allocated 2.5 hours so that I can make sure everyone understands the chapters I'm going to cover during this session. So this is my contact number. In case you have anything you want to ask me, you can directly WhatsApp to me, so I will respond to you as soon as possible. Okay, so we will start with the affidavit first. First thing I want to explain to everyone, affidavit actually itself is not a course paper per se. What does it mean by a course paper? Like our pleadings and our type of the paper we serve to the court to commence a case. Actually, it is not a course paper for affidavit. And this is a sworn statement made by the party who wants to apply for a certain action. Let's say when you are going to file a notice of application, you must be supported by an affidavit. So it is quite frequently asked in the reason papers on the technicality on how are you going to challenge the sworn statement made by the party. It's not only made by the plaintiff itself, it can be made by the defendants also. So the purpose of the affidavit is you want to tell the court what are you going to do? Because we, as a layman, we don't have the local story. Just now my connection went lost. Let me share the screen again. Okay, so just now I think I stopped at the purpose of of the affidavit, right? Okay, actually, the purpose of the affidavit is that for the party to tell the court what is what is he or she going to do? Because as a layman, we don't have the local standard to tell the court, so that instead of we directly tell the court, we file the paper, which is this one statement named as affidavit, to tell the court who we are and what are we going to do. Is that okay? This is the intro for affidavit. Okay. However, it's quite funny that affidavit itself is not an evidence. This is provided in your Section 2 of the Evidence Act 1950. You can go and refer it at your free time later. And then the next thing is the form of affidavit. What you have to do in the affidavit is you have to comply to the court. You have to comply the contents lah, which means that you have to state your name and then what happened and then what are you trying and then you have to affix your signature as well. So this one is the sample of the affidavit. This is the description of the party, the IC and who he is, and then his address, and who is he or she in this action. Can everyone see that? Okay. The next question is whether the hearsay evidence is allowed. Because the unlikely to the other course papers, an affidavit you have to put your evidence so that somehow your evidence might contain certain hearsay evidence like, oh, where do you got that? How do you know this and that? So actually, it is allowed as provided in this case, Bottenheim. The court held that the hearsay evidence is allowed, but the grounds and the sources must be given. So that, let's say today I obtain an audio recording from WhatsApp, I must extract I must extract the audio into a transcript, then I annex it as the exhibit for the affidavit. And this will be part of my evidence in the affidavit. Okay. And then the next situation is if the affidavit is made by two or more persons, for pursuant to Order 41 Rule 2, you have to insert the affidavit itself, have to insert the name of the persons in jurat. So this is how a jurat looks like. In the form number 74, I have screenshot it and attached in this slide for your reference. Okay. The question is, what is a jurat? The jurat is similar to a certificate because in the affidavit, after you already describe you already introduce yourself and then you already describe to the whole fact, then at the back there, at the back of the affidavit, you have to tell the court, you will put a certain marking on, oh, this is the first evidence, the second evidence, yes. And then the jurat is similar as a certificate to the affidavit signed by the deponent themselves. Okay. So this is how we apply for the jurat in the following situations. When the first one is when the affidavit is made by two or more than two deponents, or the affidavit is made by the blind or illiterate person. This is the sample. The sample of jurat. Okay, now here are the technical grounds. The first thing is whether the defective affidavit is accepted and allowed by the court. So pursuant to Order 41 and Rule 4, the leave of court is required for you to use such affidavit. And then the contents of the affidavit is given under Rule 5, that the deponent has to prove the facts within his or her knowledge. Which means that today I want to say, oh, someone owes me money. Then I must tell the court that, oh, I have this document to support my statement. This is what provided in Order 41 and Rule 5. And then you will see the scandalous content. Order 41 Rule 6. The court will order the affidavit to be struck up. The case is Re Ong Eng Guan. Okay, now the thing is alteration in the affidavit, which means that you want to do certain amendments, something like this. So before filing, you can do the initial or the margin, and after filing, you have to respond with a further jurat. This is given under Rule 7, but the best thing or the better option is you better file a fresh affidavit lah. Okay, now the question is who you should sworn before when you are making the affidavit, like who should be signing on the affidavit. This is provided in Order 41 Rule 8. The affidavit should be sworn before a commissioner of oath. I think everyone will be familiar who is this person, right? Pesuruhan Jaya Sumpah. Instead of others like lawyers or any other person, you must sworn before the commissioner of oath. Then the next thing is the filing of affidavit. The filing of affidavit is given under Order 41 Rule 9 at the registry of the court. But now since everything goes to e-filing already, we will just file it under the EFS lah. Okay. Sometimes this question will be asked whether the filing of affidavit earlier than the originating summons is allowed. So here are the contradicting cases. The first thing is, in the case of Ban Hinh Bank, the court held that filing of affidavit earlier than OS is a nullity and not acceptable. Therefore, the affidavit is inadmissible. However, in the case of Hong Kong Bank, the court allowed the affidavit filed earlier than the OS, and then the affidavit is admissible. So that this is this is how I memorize these cases lah. Because you see the name ban ma. Ban means you cannot lah. It's not acceptable. So I memorized this case by using this keyword ban and then the court held that the filing of affidavit earlier than the OS is not allowed. So however, in Hong Kong Bank, Hong Kong is Cantonese lah, so that in Cantonese when we say tak, okay, means yes. So the affidavit is allowed lah. This is how I memorize these cases when we answer the question. Okay. As what I mentioned earlier, right, the document annexed to the affidavit must be exhibited and identified by a certificate. This is given under Order 41, Rule 11. So that this is how does the certificate looks like. You will see this is the code of your evidence, and then affidavit sokongan to support your affidavit for the purpose annexed to the affidavit sokongan lah. And behind is the evidence. This is how the certificate looks like. Now we come to the language of affidavit. Most of the time, you will see the affidavit is in Bahasa Malaysia, which is the court language. So it's Malaysia lah. The Malaysia at the front. So that some of the lawyer that will do a translation for the benefit of their clients, so that their clients if they are not good at Malay, so that they can still refer the English version to have a better understanding. So that you must make sure that when you file the affidavit, in front must be the Malay version, then behind you can accompanied by a translation copy. But however, this is given in Order 41, Rule 13. If it is outside of the jurisdiction, you can file in English language. Unless the court orders, you must file in that particular language lah. Are we okay? Okay. Now we will come to see this partial question. The reason why I purposely find the partial questions for everyone is to make sure that everyone understand and familiar to the partial question on how could the chapter comes out as the exam question, so that at least you all wouldn't got trapped by the examiner when they just twist and turn the fact lah. So the first thing is, as you can see, the plaintiff filed the OS to the High Court against the defendant. Then the following contents to the affidavit was being objected by the defendant. So the first thing, the affidavit was affirmed 3 days before the OS to be filed in the court. So it will comes back to just now the two cases I have explained. Let me find out. Yes. So your answer, since you see this is a 15 marks question, so that here are 5 parts, which means that each of the sub question will be allocated for 3 marks. So that using the 2 cases to answer the question will be very sufficient. We will use the Ban Hinh Bank and then contrast with Hong Kong Bank case. Then the first part we already settled. Now, the second one is in respect of the exhibits which was annexed to the affidavit, the certificate of the commissioner for oath was not included as an exhibit. So this will so when you see the thing like related to the commissioner for oath or the certificate, you can just either you go to 11 or rule 8 on based on the fact that the question is on the certificate was not included so the certificate, yes, is under order 41 rule 11. So you just put your answer there as provided under order 41 rule 11. It must be accompanied by the certificate to identify the evidence on the fact it's not followed. You can move to the third question already. In another exhibit, the print was not clear and it could not be read. So actually for this one, unfortunately, none of the rules under order 41 is applied. Does anyone know why? I don't think so. It is clerical, is on the clerical error because it was stated here that the print was not clear and it could not be read. So I don't think so. It's a clerical error. Is that the defendant could not read the document because the printing is not clear, so that he's not able to see what is inside the affidavit. So actually, from here, what you can do, order 24, discovery, you can compel the plaintiff to provide you the document again. This is the trick. And quite tricky on this part is because I think when you see this is what I really experienced, when you see the entire 15 marks is allocated to one whole as a whole, you will think that it will be binding under the same chapter, but unfortunately this one is not. So that to answer this question, right, since you cannot see what is the document and you want to get the document for you to know what is the evidence about, you can use the order 24, which is the discovery action, to compel the plaintiff to provide you the document. Is that okay? Okay, now the fourth part is the name of the plaintiff was misspelled and was altered to show the correct name, but the alteration was not initiated by the plaintiff, but only by the commissioner for oath. When it comes to this one, obviously we can only do is the alteration of the affidavit, which is rule 7. This is clearly shows that the plaintiff did not comply to the affidavit rule. Okay, the fifth one was affirmed in Singapore, found in English language, not in the national language. This is what we have covered just now, the language barrier, rule 13. So as long as we know that the affidavit is affirmed outside of the jurisdiction, it can be found in English version, no issue. So since we already covered this question, right? I will type in maybe I will just share with you on how to answer this kind of 15 marks question. So you must start with the subheading so that there are five parts, right? The first part, the first subheading is to answer the first sub question. Then, uh, then you can maybe you can add your conclusion at the end or in between. It's up to you. As long as you already differentiate it into the subheading, then it should be fine lah. It's because from the thing is the first one, the plaintiff can rely, the defendant can rely on Hong Kong, can rely on Ban Hin Lee Bank to raise the objection. Then the second one is okay, can be raised as well. Then the third one is not relevant. Fourth one is object. Fifth one is he cannot object. So that you can either make your conclusion in each sub questions or your subheading lah. Or maybe you want to do a general conclusion like as a conclusion, the defendant's objection is sustainable for first, second, and the fourth one. However, the third and the fifth one, his objection could not be stand. This is how you going to answer this type of question. Do anyone need me to further explain it for this question? Because I also worry that I'm going a bit too fast and then somehow I will confuse anyone here lah. Because I understand that everyone now first thing is very stressed because the exam is around the corner. And then the second one is to have a lot of inputs lah during these few months. Some of you all might a bit struggling on to understand and know how to apply so that if any one of you needs my explanation on that part, just type in the chat and then I will go and then I will explain it again. No worries. So we will come to the next question. So for this question, maybe you all can read first and then you may put your answer in the chat so that I will see and then I will point it out on your answer. Okay? Okay, I can see the answers in the chat already. So the first one, the fact that he's unable of his knowledge to prove. This is given under Order 41, Rule 5, so that we can follow to the case of Bottenheim, so that the court held that the evidence is allowed, hearsay evidence is allowed, but the grounds of the sources must be given. Then the second, one, and also you have to put this as well. Then the second part is on the scandalous content, Re Ong Eng Guan, Order 41, Rule 6. You must use these two things, and then you will order, then the affidavit can be struck out. Then lastly, the exhibits did not contain the certificate of the commissioner for oath. This is given under Order 41, Rule 11. Must be exhibited, identified by a certificate, so that based on the non-compliance, the affidavit can be struck out. But one thing, when near irregularity, let me think about it, because someone has asked me a question. Okay, I think there's a very good question here. If you did not comply, whether the court is just struck out or it's just based on mere irregularity, and then the party can refile the affidavit again. But as given under the order and rules, the court just struck out. They will not allow for, they will not allow you that they wouldn't say that this is just a mere irregularity lah, to be honest. Okay. Okay, here is the latest paper during my sitting lah. So you all can have a look first. Actually, the thing is, I found out that most of the time, in for the questions of affidavit, right, they were just asking you on the technicality and how to challenge the defective inside the for the contents of the affidavit, so that you see it's quite repetitive. The first part is contain hearsay evidence. We already got the Bottenheim case, and then on how to overcome the issue. Then the second thing is scandalous issue again. The third one is did not contain the certificate again. Then, okay, the fourth one, the address of the defendant was erroneous. So you see, most of the time they will ask you, this is how the questions being asked. The reason why I purposely find the questions and then to put in this slide is because I want to get everyone to be familiar into the exam questions on how could the examiner ask you for this chapter. So we already covered the affidavit chapter. So anyone have the questions to ask before I move to the next chapter? Okay, we will move on to the next chapter, which is the pre-trial case management. Actually, the pre-trial case management is that it's just like what you have studied in your criminal procedure. Before the full trial, there will be case management, like the court will give you such direction on what the parties have to do before the trial, and then what should they prepare, and the orders given by the court if you did not comply to the direction. So how when does a pre-trial case management commence is that when the pleadings are closed. The pleadings we already covered are statement of claim, defense, and then the reply, the rejoinder, sure rejoinder, this and that. After the pleadings are closed, which means that when the court already tell the parties that okay, pleadings are closed, they will fix for a pre-trial case management on what should the parties do for the next step. Okay, so the purpose of the pre-trial case management is for the parties to compile the relevant document to support their case, and it also enable the parties to identify their witnesses, because during a full trial, right, each party will have their own witnesses, so that you will have to prepare a list of the witnesses for your own side. Like the plaintiff will have their own of witness, then the defendant will have a set of witnesses, so that you have to get the parties to know that who are their witnesses lah, which means okay. So power of the court during the pre-trial case management is given under Order 34 Rule 1, where the court has the power to make order or direction as it thinks fit. This is the screenshot of the rules of court. Then the second thing, actually I was a bit struggle when I'm dealing with this question, when I'm dealing with this rule, because previously without any working experience, I wouldn't know what are the Part A, Part B, and Part C documents. Actually, inside when we want to tender the documents to the court, the parties will have to file a list of we have to file few bundles, like bundle of documents, Part A, B, and C. So actually, the reason why they classify it, I have already explained as below. The Part A is the agreed bundle of documents by both parties, which means that you will not challenge on any documents under the Part A. Then the Part B and Part C, the other party, the opponent can challenge when they are doing their cross-examination. So that how to differentiate between the Part B and Part C? For Part B, right, the authenticity of the document is not disputed, but the contents are being disputed. And the Part C, authenticity and the contents are disputed by the parties. So some of the examples for the Part B documents are bank statements. Then for Part C, actually it's everything, like your WhatsApp, transcripts, and then your photos. That's some of the examples appears in Part B and Part C bundle of documents. Are we okay? Okay, this is explained in the rules of court. Okay. But the thing is, I'm just putting here and then explain to you also that you all have a better understanding now. Okay. Notice to attend the pre-trial case management. This is given under Order 34 and Rule 3. The parties shall be informed of the date and time schedule for the pre-trial case management. So that now, because every legal system are using the e-filing system, so that if you are the lawyer representing the client, right, you receive a notification in the portal that telling you, on which particular date you have a pre-trial case management, or you can search your case online, and then you will see the notification on the date to be fixed lah. Okay, the attendance of the pre-trial case management. So that this is given under 34 and Rule 4. The attendance is by the respective solicitor of the party. So sometimes, let's say today I'm representing the plaintiff, but the thing is, I'm also attending to another court matter, so that this is what a counsel mentioned on behalf takes place. So that maybe I call another lawyer, go to attend for the pre-trial case management, to to attend the pre-trial case management, and then he or she have to brief me back what is the court's direction to ensure that my case will not be struck out by the court lah. Or maybe sometime the party can attend to the court personally with the leave, so that because a pre-trial case management is not open to public, because this is the direction given by the judge to the solicitors who are to discuss the matters, so that it's not open to the public, and that is the reason why only the lawyers or the counsel mentioned on behalf can attend. Okay, just now I've covered that if you did not attend to the during attend for the pre-trial case management, the court against the plaintiff may dismiss the action. So if against the defendant, if the defendant's lawyer fail to attend, the court may strike out the defense or counterclaim or enter into the judgment. So, however, the aggrieved party may apply to set aside a court order by filing an application. Are we okay? Okay, now we are coming to the partial question. You may have a look first and type your answer in the chat. Okay, I've seen a lot of answers. Let me check again. Okay, generally, I can see the answers are quite on point and correct already. Because the thing is, you have seen because the thing, this question including two issues. The first thing is non-compliance of the direction given during the pre-trial case management. So this is given under Order 34, Rule 2, Sub 3, that the court may have the power to the court may have the power to set aside to strike out the action due to non-compliance. Then the second issue is on the non-attending, so that yes. So order 34 rule 6 is failure to attend the court may dismiss the action also. So that these are the answers lah. So you can either put an intro telling the examiner that this is the so actually most of the time when I do the questions, right, this is how I'm going to structure my answer. The first part is you have to tell the examiner what did you identify the it's okay for those sharing. Okay, so this is how I'm going to structure my answer most of the time. First thing is you must put an introduction and tell the examiner what have you identified in the particular question. The intro is just a very brief intro, like you are telling to the examiner that oh this question is so pertaining to what and what. And then when you move on, then you go to the issue that you have identified. Okay, the first issue is non-compliance of the pretrial case management direction. Then you explain and put order 34 rule 2 sub 3 and then move on to the next issue. The next issue is non failure to attend the pretrial case management. After you have identified these two issues, then you put your conclusion. That's how you answer. That's how I answer actually lah. So that at least you can show to the examiner that you have a proper structure of your answer to get the mark. Okay? Okay, the next question is the main question of 2019. So actually, this one is it's just a 5 mark question. Since this is a 5 mark question, you can just have a quick read and maybe you can already identify what are the issues already. Okay. Now, the question is concerning that the party which is Panda Secure Sdn Bhd did not follow the court's direction. So that it's very clear cut and simple that Order 34, Rule 2 and Sub 3, that the court has the power to dismiss the action because of non-compliance of the court direction. Okay, now we come to this paper, 20 and 20 main paper. So that this one is the reason why just now I point out the Order 34, Rule 2, which is the classification of bundle. As you can see, the plaintiff sue the defendant for defamation. So one of the document marked as Part B, and which is an email written by Zamri, the defendant's business associate, stating that plaintiff has admitted the truth. And then at the trial, the counsel wants Zamri to testify on the email written by him. Can the defendant's counsel do so? So actually, since this is on the 6-mark question, actually, as a witness, when you are the witness in the action, you have to testify. Okay, but whether you can be testified pursuant to that particular bundle of document, you have to refer back to your Order 34 Rule 2, which is the classification of documents. On the fact itself, this is a Part B document, so that as what I explained just now, the counsel can cross-examine from the bundle of document from Part B onwards, so that yes, the counsel can question on Zamri based on the Part B document. Are we okay? Okay, now we move to the reason paper, which is the 20 and 22 main paper. The defendant's counsel, due to the oversight, failed to attend the PTCM of the suit, which was heard by the judge. Counsel for the plaintiff was present. Due to the absence, the judge struck out the defense, the statement of defense, entered the judgment for the plaintiff. Advised the defendant whether he can set aside the judgment. Okay, so this we can go back to the Order 34 and let me check again. Okay, this is provided in the Order 34, Rule 2 and Sub 4. You may go and have a look at this. I will type in the chat group. But anyhow, when you want to set aside, right, bear in mind that you have to substantiate with a good and valid reason. It's just not like it's not like, oh, I want to set aside, then I make an application. You must have a very good and valid reason to substantiate your application. So along this chapter, does anyone have question on this? Okay. Now we will come to a full trial. Actually, I found out that this will be a very, very lengthy and a bit bulky because this chapter may not appear in the question for frequent, but it's also good for you to understand the whole process of a full trial. So maybe we can take a 5 minutes break, and then when we come back, I will I'll be sharing what will be covered in the full trial. Okay, I will see you all in 9:35. Okay, do I have everyone here? Okay. Now we will come to the full trial. For this chapter, right, I will be covering the procedures during a full trial and the technicalities like the what you have to comply and what you have to do during the full trial and the consequence of non-compliance. And also, this will cover what is the next step after a full trial. Okay, the first part is what is the difference between the pre-trial case management and the full trial? So the first difference is the pre-trial case management is not necessarily open to public, but a full trial is open to the public, which means that everyone can sit in to be the audience. And then the next thing is the pre-trial case management is attended by the party's own solicitor, but the trial is attended by the witnesses or anyone related to the action. So the next thing is, what are the procedures during the full trial? The first thing is the counsel must attend to the trial, must attend at the full trial. And somehow actually I have been through for one case where the plaintiff he has no money to appoint a lawyer, so that instead he himself represented, it's a self-representation now, so that he himself is representing the plaintiff, and then he conducted the whole trial. It's not a joke, but it's true that the plaintiff conducted everything like a lawyer in that action, but this is civil action now. So that he has his own witnesses, and then he has to cover the filing of court papers, and then the relevant procedures. And now the procedure for the full trial is you have to go through the examination of witness, like what you have studied in the Evidence Act. You will go through the sequence like examination in chief, cross-examination, and the re-examination. Now, what are the parties can challenge during the trial? The first thing is the preliminary objection. This is given in your Order 33 Rule 2. And nevertheless, when you want to raise the preliminary objection, you also have to remember this case, Bukit Melita, Sdn Bhd. I think this is covered in the chapter 1 where you want to raise the preliminary objection. Pursuant to the Bar Council ruling, you must serve the notice to raise the preliminary objection to another party within certain days. Otherwise, it is deemed as you already waive your right to raise such objection. Okay? So, furthermore, in Order 32 Rule 5, 33 Rule 5, sorry. 33 Rule 5, the court has the power to dismiss the action or make the order as it may be just. So here is the Order 33 Rule 5, what it is stated. So with regards to the preliminary objection, here are the cases on point. The first one is Thailand. The court allowed the preliminary objection, which is the limitation period. Then the second case is Tan Guan Eng. Local standard is one of the preliminary objection raised by the party. Now, during the full trial, right, if the what is the consequence if the plaintiff absent? You have to see if the defendant has no counterclaim, the plaintiff case will be dismissed. This is given under Order 35. Sorry, just now I guess I tapped wrongly. This one is 35. Okay, So if the plaintiff is absent, pursuant to Order 35, Rule 1, Sub 2, where the defendant has no counterclaim, the plaintiff case will be dismissed. However, if the defendant has a counterclaim, the court will give the judgment in the defendant's favor, which means that it's like which means that the defendant will obtain the judgment in his favor that the plaintiff has no case . However, the plaintiff may apply to reinstate the action within 14 days and is subject to the court's discretion to extend the period. This is given under Order 35, Rule 2, Sub 2 and Sub 3 of your Rules of Court. Now, just now we are really talking about one parties, right? So if there are two parties, both parties are absent, then Order 35, Rule 1 applies. However, if the defendant is absent, yes, it's still same. And then whether how can the defendant reinstate the action? You still have to follow back to Rule 2 and Sub 2 to reinstate and file your application within the 14 days rule. Now the question, this is the question whether the refusal of reinstatement will be resulted as res judicata. Actually, the Latin term res judicata means the court has already adjudged the case, so that since these are absent by the party, this is due to the absence of party, and then the court refused to reinstate the action, and this is not a final judgment yet, so that this is explained in the case of Karam Singh. The court held that the plaintiff may file a fresh action within the limitation period, and this will not caught by res judicata. The next thing about adjournment is whether the court has the power to postpone the case. Yes, it is from time to time subject to the discretion as per Order 35, Rule 3. However, this will go to whether your reasons for for apply for postpone are valid . And then here are the factors considered by the court to decide whether or not to adjourn the case, so that as given in practice direction. First one, these are some of the examples I have taken out . The first thing is legal representation, which means that you are attending to another case, or the lawyer is attending to another cause, or due to sick or attending another seminar. However, the court will also consider the following factors, such as how many times did the party apply for the adjournment, and then who are the party requesting for adjournment, and whether there are any good reasons. So we will come through the case law like Go Pak Hong Tractor. In this case, the court held that the flight delay is not a good reason to apply for an adjournment, as this could be done earlier . And then also in the case of Diana Chu, the plaintiff has applied for 4 times for the adjournment, so that the court also refused to allow the application. And this is quite recently, especially during the MCO times. Previously, when around 2017 or 18, I think there is a KPI for the court to finish for. They already set a KPI for the judge to finalize the case within a certain period, especially during MCO, because the court has been stopped for operation like few months, and then a lot of the previous cases drag until today. That is the reason why the KPI has pushed them to close the matter or finish everything within the given time frame, so that now the court will not simply give the adjournment already. Okay, so during the trial, in regards to the order of speech, right? Mostly lah, I would say mostly lah, plaintiff will start the speech first because the plaintiff will have to start their speech by introducing the party. Okay, so this is how a trial being conducted. The first thing is the plaintiff solicitor will introduce the court, the parties, and then what what is the action as of today? Like today I'm going to proceed with the which witness, and then he will start his speech first. Then the witness will then come to the witness standing, and then the witness will come to that kandang and then sit there and proceed with the full trial. That is the reason why the order of speech is on the plaintiff's side. Now, the examination of witness, I think you all have studied in your evidence law that the sequence, which is examination in chief, your counsel asking the party's counsel asking on the witness, and then the cross-examination, the witness will be challenged by the opponent counsel. Then the re-examination will be taken place if there is a necessary. What does it mean by necessary? Which means that because sometime, right, during the cross-examination, the witness may be asked for certain questions that not in his favor, and he is not fully answered, and then like making himself looking not very good, like he is not really answered to the point that if he raises the point that he wants to explain, then this is so-called the necessity for the re-examination, so that the re-examination is confined to the question being asked during the cross-examination. You cannot depart from that. Like, oh, I want you to explain certain things which was not covered in your cross-examination. This is not allowed. Is that okay for everyone on the re-examination part? Okay, thank you. Okay, so the next question is whether the witness can be called after the close of their case. Like, let's say now the plaintiff has closed their case, which means that the plaintiff witness or witnesses are being asked, so that now it's about to go to the defendant's case. And then now the plaintiff counsel wants to ask, oh, we want to recall back the witness. Whether this is allowed, you will see the case of Tan Ka Kiam. There are two requirements. First thing is unforeseen circumstances and inadvertent omission. And then the second requirement is it will not prejudice other parties. So that actually is very, very subject to the court's discretion whether or not they want to allow this particular witness to be recalled. Now the general rule on the examination of witness. Order 38 Rule 1 provides that the witness has to be examined orally. Then the Rule 2 is in the writ action, the witness will be asked pursuant to the according to the questions inside his witness statement, so that basically each of the witness will be, you have to prepare a witness statement for them, and then in the witness statement itself, you will list out a number of questions like, first thing, who are you? Then what are your occupation? And then you will only go to the fact of the case, and then each Q&A will be listed and filed into the court. This is the witness statement. However, if that particular witness is absent during his turn, the witness statement shall not be deemed and received as an evidence, because you cannot ask the heir like, hey, you agree or not? Is this what you did? Cannot, right? So that this is the essence of the Order 38 Rule 2. And then the second one is in the OS action, all evidence is based on the affidavit, so that the person of the affidavit shall be examined. Otherwise, the affidavit is inadmissible because the maker is not there. You cannot challenge or you cannot examine the person who is not making the affidavit to give you answer, right? So this is what it explains. So just now, the contents of the witness statement I already explained is that the basic information and then the facts related to the case. And it has to be served to the other parties as well, so that it is given under Order 38 Rule 2 Sub 4 that you have to serve on other parties not less than 7 days before it is tendered and read at the trial. So which means that after you file, you must serve to the other party in due course. Now here is the sample of witness statement, so that as you can see, this one is the entitlement in the High Court of Malaya, Kuala Lumpur, and then the description of the parties. And then for your information, enclosure number actually is how many documents it fall into the court, basically. And then this is the witness statement. So due to the P&C, I have already censored them. So you will see the witness statement of this person, name, IC, and then address, so that you have the first question, and then the witness has to explain that who he is or who she is, and then the IC number and the basic details. Then it goes on to the facts of the case. And then subpoena, when it comes to subpoena of witnesses, does everyone know what does it mean by a subpoena witness? Have any one of you heard that? Okay, the subpoena witness is when it oftenly deals with the public authority, like the motor vehicle accident, right? The sergeant or the police officer who has went to the scene and taken the photo or who made the police report, you have to subpoena he or she to attend to the court and give his evidence. This is the subpoena witness. So that somehow it also can be list of your witness. Depends on the case. So that when the party require a particular witness to give evidence in the court, you have to subpoena that particular witness. And pursuant to the Order 38 Rule 14, you have to serve the praecipi together with the subpoena. A praecipi actually is a form containing the details of the solicitor, like which lawyer firm you are from, and then you want him to attend this, and you want to attend this court on this particular day and time. And then how to use service of the subpoena is given under Order 38, Rule 18, by way of personal service. Because at the end of the day, whether or not you effect the service of the subpoena, you have to put it in your affidavit. The affidavit is made by the runner that on that day, he was attempting to serve the praecipi to the witness and the subpoena, and what happened during that. Oh, he was there, and then I effect to serve. Okay, he was not there, and then I have to plan for another term, and then what happened later on. This is given under Order 38 Rule 18 and 23. The personal service, how to effect the service lah, and what you have to do after the service. Then the 22 is reasonable have to be given lah. Okay, I will do the amendment later. Must be given lah. Actually, the expenses itself is for the purpose to cover the transportation. Like you want the witness to attend to the court, and how much does it cost? Like the transportation, the meal. Most of the time, we are giving 100 because if you are attending for 1 day trial, 100 I think is quite reasonable already. Now we come to this submission of no case to answer. Submission of no case to answer actually is like you are playing a very risky game because I think you all have covered in the criminal procedure. One is the Chombusi, one is the Lee case about the submission of no case to answer. Submission of no case to answer basically means that after the plaintiff case, if the defendant is in the opinion that the plaintiff did not establish that case, and or the case did not, or there is no credible evidence, so that to differentiate, during my first time to study the submission of no case to answer, I thought that when the plaintiff's case is weak, then we can make a submission of no case to answer. Actually, it's wrong. You must make sure that the plaintiff has not established the case, not his case is weak. Because when you already made the submission of no case to answer, you will not be able to make your defense when your submission of no case to answer is fails. Actually, in Malaysia, under the rules of court, it is silent because this concept is an English practice, so that the cases on point here I have provided are the English cases. Subpoenas. Okay. Sorry, I just got one question from here. Okay. But never mind, if you want me to actually this PowerPoint will be shared to our pro bono chat group later, so that if you cannot catch it, yeah. Okay, so I have seen one question here. What is the effect of a submission of no case to answer in the context of a criminal trial? Actually, the concept is the same. It's the same. Because when the defendant has made a submission of no case to answer, basically it's like how we play the game. We put all in, so that if you win, okay, the chance is on you and then you secure. If you fail, you cannot enter into defense, that means you're gone already. So the concepts are the same, just that in criminal case, in Chombusi, the differentiate between Chombusi and Lee Kuan Yew is whether the defendant was given the option. In here, actually, we have 3 cases, but it's quite similar, just that criminal procedure, we are using the Malaysian case, but civil procedure, we are using the English case because rules of court is silent on the submission of no case to answer. That is the reason, but it's still the same lah. So that in U&U, this explain on what authorities here are. Okay, I have sorry. Okay, I have put the 2 cases in the chat box already, so that in criminal procedure, the cases we are relying on when we are talking about the submission of no case to answer is Chong Bu-si and Lee Kwan Woo. The difference between the two cases in the criminal procedure is whether the parties are given the option. So that if you are given the option already, then you make a submission. Then when your submission fails, your case gone. But in civil, we are still relying on the same concept, just that in you and you is basically to explain what is a submission of no case to answer. And then another case is Lorry, where the defendant is not allowed to enter to make his defense when he already made a submission of no case to answer. Basically, this is because the parties are not allowed to take the second bite of the same cherry, which means that you cannot have a double defense. It's like the first round, you already make your defense that, oh, the plaintiff has no case. And now, because you lose already, you are enjoying a double protection while the other side is having a double jeopardize, so that it is not allowed. This is what explained in the case of Lorry. Okay, I see one question on the accused must be given. Yes, this is what I'm going to cover. In the story, actually, it's not necessarily in civil, because I didn't see much lawyer who do that. Yeah, but in civil, in criminal trial, yes, following the case of Lee Kwan Woo, the judge, the court has to give the option for the accused whether or not he wants to make. But in civil trial, very rare I have seen to be honest. But in the case of story, if the defendant is not given the option, he is then allowed to make the defense if the submission failed. Are we okay? Mr. Judge. Mr. Judge must explain to him. Sandeep, I guess during the criminal trial, right? You will have a lawyer to represent you, so that the option to make the submission of no case to answer is done by a lawyer lah. So your lawyer must be good enough to understand what are the consequences after he has made the submission of no case to answer. But in civil trial, so what is the consequence? So the consequence is, if you win the case that win at your submission that the plaintiff has no case to answer, then you won the case lah. But if you already fail at your submission, which means that you already surrender your right, because the submission of no case to answer is basically that I'm giving all out to say that the plaintiff has no case. Now I'm challenging you. You are a loser. So in fact, when the court turns out and say that no, the plaintiff has a case, maybe the case is weak, doesn't mean that he has no case. Your submission of no case to answer is failed, and then your case gone lah. You lose lah. Criminal context. Then he's not allowed to make the defense already. In criminal, I think this is explained already. He's not allowed to make a defense. That means at the end of the trial, the court will determine the prosecution's case and give the judgment when you make a submission of no case to answer and then you fail. Did I explain to you? Yes. Okay, now we are coming to this question. This is 20 and 18. You're appointed, you are the appointed counsel to represent the defendant in the court on the trial date. Then the defendant is unable to attend on the court on the trial date. Then your request to postpone the case is not granted. The trial commences with plaintiff giving evidence. At the end of the plaintiff case, it's clear to you that the plaintiff has not proved his case in law and that his evidence is not satisfactory and unreliable. And then the judge has directed you to proceed with the defendant's case. Now, what should you do? This is a very typical submission of no case to answer. Because the first, there are the clues here. The first thing is the plaintiff has not proved. Can everyone hear me? Okay, so now, okay, I will move on to here that just now I already said that there is a clue that the plaintiff has not proved his case in law and the evidence is not satisfactory and unreliable. So that this is very clear that it is related to the submission of no case to answer. And now you can see how do you structure your answer. I will explain. I will type in the chat box. This is how I'm going to answer. Mhm. You can start with your intro on what is the question is concerning. Okay, this is how I'm going to structure my answer as what I've shared in the chat box. This is an 8-mark question. So that the first thing is intro. Introduction is you have to tell the court, you have to tell the examiner, sorry. You have to tell the examiner what is the question about, submission of no case to answer, and then you can start to explain the use case where the plaintiff did not prove his case in law, which means that he did not establish his case. And then his evidence is not satisfactory and not reliable. Once you have finished these two parts, then you can proceed to conclude your answer already. So this is how to answer the 8 marks question like this. Then are we okay with the structure? Okay. Okay, now we will come to this 2020 paper, and then I would like to have you all to have a quick read first. Then you may post your answer in the chat box. Then I will read the chat box and answer you all. Okay, I guess everyone has read the question already. So we'll come to read the question again. So on the trial day, the plaintiff and his counsel was present. Then the defendant was absent. However, when the counsel absent was present, the defendant's counsel applied for the adjournment, which was refused by the court. When the plaintiff opened his case and after the testimony of the plaintiff was concluded, his counsel requested for an adjournment to produce a witness to tender an original document, which was crucial to the plaintiff's case. The request was refused, and the plaintiff counsel was asked to close the case for the plaintiff. Then the defendant's counsel was then asked to open the case for the defendant. So actually, it's quite tricky to ask you on submission of no case to answer, because you will see the wording being used is more like whether or not you can ask for an adjournment. But in fact, it was actually concerning about a submission of no case to answer, because at the end, you see, under these circumstances, what is the most appropriate step in the proceeding that the defendant's counsel should adopt? So if your answer is based on the adjournment, I am so sorry you did not answer to the question, but instead it is concerning on the submission of no case to answer. So that to answer this kind of question, the structure of what I have given earlier is remaining the same, where you have to start by introduction, then goes on to the on what is a submission of no case to answer, then you make your conclusion. Then we move to the most recent paper. This is also the same, because it's quite similar the way how they ask the question. During the trial, and then the plaintiff did not establish the case, what should the defendant do? Okay, so it is concerning on the submission of no case to answer. So from the repetition of the trend, you will see how can the submission of no case to answer being asked in the exam question. Are we okay on that? Okay, now we come to the assessment of damages. So the assessment of damages are every time when you make a statement of claim, right, you will put your prayers like special damages in the certain sum, and then the general damages or any specific performance or in lieu, and then the other relief. Actually the damages is referred to the general damages. So on the damages, right, actually is the assessment of the damages is for the court, is for the party to compensate the is for the defendant to compensate the plaintiff due to what he has suffered as a result of the negligence by the defendant. So that under Order 37, Rule 1, registrar is the one who can make the assessment, so that the parties are entitled to apply to the registrar within 1 month to make the assessment of damages. And then Rule 2, the registrar will give a certificate on how much does the defendant has to compensate the plaintiff. Then Rule 4, the court also has the power to order the assessment by the registrar or during the trial. Now we will come to the judgment. The judgment actually this is referred to the final judgment now. The final judgment, the judgment itself is defined as the decision given by the judge at the end of the trial. And this will be the finalized of will be deemed as the final of that matter really. So after the judgment is given, you may rely on that judgment, and then you can decide whether or not you want to proceed it to the appeal. Because this is given in your criminal procedure as well, explained in the case of Ang Jin Lee. You must it must be a final order so that this is what judgment explains, so that the delivery of judgment is given under Order 42 Rule 1 in the open court. And if the delivery of judgment in chambers, you have to pronounce it in the chambers or the open court. And then the judgment has to be signed by the which has been signed by the judge must be filed. And the date of effect of the order is given under Order 42, Rule 7, from the date of pronouncement. The reason why the date of effect is very important, because this is how your limitation kicks in. So the limitation period for you to enforce a judgment is given under a Limitation Act is 12 years from the date of the order. So that when you already have the judgment on the particular date, is your 12 years start counting from the date. Okay, so it also comes with the interest, and the interest as provided in practice direction is 5% per annum. This is I also copied the link for everyone to have a look lah. You may just do it as for your reference purpose. Now the question is whether you can set aside the judgment. Yes, you can set aside the judgment within 30 days, sorry, from the date of the judgment. This is given under 42 Rule 13. Now, how do we know that whether the judgment is perfected? The judgment is perfected when the official seal is affixed, and this is how the official seal looks like, the two tigers. Okay, whether the court has the power to alter or override the judgment actually is no, because the court is the functus official, no power to re-examine the decision, except if they want to amend the judgment due to the slip rule as given under Order 20 and Rule 11. So actually, if you want the court to amend the judgment, right, unless it is under the circumstances like the clerical error, yes, then the court has the power to amend. Are we okay? Okay, we will come to the consent judgment. The consent judgment is like a contract. Actually, it's a contract. Like both parties has come to a consensus to finalize the case without waiting the full judgment given by the judge. So that let's say right now we are already during a trial and almost end of the trial, right? You can have a settlement. You can have a settlement between the parties, and then they will have their own conditions, like what he can accept and what the other parties can afford. So that this is how does a consent judgment prepare. So each party will give the options that they can accept or they can afford. And then whether or not the consent judgment can be set aside the right of being challenged, yes, this is provided in the case of IJM construction, where the court set aside the consent judgment on the ground of misrepresentation. As what I have explained just now, a consent judgment is like a contract between the parties, so that misrepresentation is one of the reasons that the consent judgment can be set aside. And how to set aside a consent judgment? This is given in the case of Yixing Plantation. The consent judgment can be set aside by filing a fresh suit. Unfortunately, this one was not being asked in the exam. That's why I couldn't find the past year question for everyone to have a look. Okay, are we okay as of now? Okay, I will move to the final chapter of today's session. So, the judicial review. A judicial review, actually, I think during my first session, when I was talking about the cause of action on the negligence by the government authority, the limitation to bring an action against government's negligence is 36 months, which means that 3 years from the date when the cause of action arises. So actually the time one of y'all asked me like the Ahmad Zahid's case, whether we can sue the AG for negligence. Actually is not under any negligence suit lah, because that one is a judicial decision already. So what can we do is we can file an application for judicial review for the court to review the decision made by the authority. And then actually Bar Council has made the attempt to it. And I have also included the link for your reference. So the purpose for a judicial review is given is given in the case of Ahmad Jeffrey to challenge the decision made by the authority, and then the party has been adversely affected by the decision. So there are type of orders can be made for the judicial review. Habeas corpus. I think you all have learned it in your criminal procedure in the chapter of arrest. What can you do when the person is wrongfully detained by the police officer? You can apply for the habeas corpus, and this also can be made for the judicial review. And then mandamus. Mandamus is a court order to order the public authority to perform an act. And then this one, the certiorari, is an order to quash the decision made by the tribunal or the public authority. Now the requirement to apply for a judicial review, as I explained in the case, as I have discussed in the case of Ahmad Jeffrey and also in this QSR brands, the court held that the party must be adversely affected by the decision of the public authority. The reason why the decision is very important because of sometime it is not a decision but a mere discussion. Like today, I was in the reliable information. I have a reliable information that the government is planning to build a certain thing in my housing area. So because it's not decided yet, so I cannot apply for judicial review unless it is a decision made by government, and then it comes with news that they decided to do this on my housing area. Then yes, because of that, I've been adversely affected. Then I can file an application for judicial review. So that you must make sure that it is a decision, not a discussion. So, and also this is given under Order 53, Rule 2 and Sub 4. Any person who is adversely affected by the decision of public authority shall be entitled to make the application. Okay, and now we are coming to the stage of procedure. First thing is you must apply for the leave of court. You must apply for the leave under Order 53, Rule 3 and Sub 2. And then we will see the wording. Application for the leave must be made ex parte to a judge in chambers, supported by a statement. Basically, when you see the question of judicial review, right, you can just copy this Rule 3 and then Rule 4 and then another one to complete your answer. I will explain to you later. And then the service of the notice of application must be given not later than 3 days before the hearing date to the AG chambers as provided in Order 53, Rule 3 and Sub 3. Once the leave is granted, then the procedures under Rule 2 and Rule 4 will be followed accordingly. So that, as you can see, what you have to do under Rule 2 and under Rule 4, then actually you already have your answer there. And then the question is whether there is any time frame for the parties to apply for a judicial review. Yes, it is given under Rule 3 sub 6. The limitation period is 3 months upon the decision is made. And this can be defined in here. Shall be made promptly within 3 months from the date of the grounds, from the date lah. Okay, so we will see the past year question first. Okay, has any one of you read the question? Hey, sorry. I think this one I've included wrongly. This is not JR, sorry. Okay, sorry. I guess this one. Sorry. This is the correct question. Okay, this is the actual question of the judicial review. So on this particular date, the Minister of Education approved the relocation of the primary school at Jalan Pandan. Thomas is of the view that the Minister of Education failed to consider the view of the residents in the area surrounding that and wanted to challenge the minister approval. However, none of his children is studying in the primary school. Advise Thomas in reference to the appropriate procedure and the relevant legal requirement in challenging the approval. So actually from this case, right, from this question, right, you will see the first thing is when you want to make sure that you can file the application for judicial review, the first thing is you must be adversely affected by the decision, right? As given in the case of QSR, and also your Order 53 Rule 2 sub 4. So actually, you see the question, right? Since it's given 15 marks lah, I guess you have to include quite a number of points. So the first thing is introduction. You have to tell the examiner this is concerning the issue of judicial review. Then you explain the case, like how to justify whether he can make on how to make a judicial review lah, like the QSR brand. Okay, now after you have explained the issue, then you come to the procedure. The procedure is you must make sure that Order 53, Rule 3, Rule 2, Rule 4 has complied. Then at the end of the answer, which means your conclusion, based on the fact that none of Thomas' children is studying in the HP primary school, he is not allowed to file the application for judicial review. So this is how are you going to answer the 15 marks question. Because if 15 marks question, you straight away and you directly tell them that, oh, you cannot, because you have no locus standi, this and that. Yes, you can say no locus standi, but you must put it at the end of your answer. Because this is a 15 mark question, if you write your answer into the short line, right, you will not secure, you are not secure actually. So that this is the logic of the 15 marks question. You have to explain first, or these are the procedures that a judicial review has to comply with. Then at the end, you say, oh, based on the fact that he has no locus standi, and then he was not, I wouldn't say that he has no locus standi because he's a politician active in the community. But the thing is, none of his children is studying there. So that he was not adversely affected. And then this is why the judicial review cannot be stand. Okay? Okay, this is the 2017 question. Kumar was employed as the medical officer on the 3 years contract from 2016 by Hospital Kuala Petaling, Sembilan Berhad. On 15th of May, he received a letter informing that his employment contract has been terminated with immediate effect. The reason was that he has breached the terms and conditions of his employment, but no details were given. And then, being dissatisfied, Kumar had made a representation for reinstatement under the Industrial Relations Act 1967. However, he received a letter informing that the Minister of Human Resources had made a decision on 30th of April that his representation was not fit to be referred to the industrial court for an award. Now, how can he challenge? So, on the fact that this is a 10-mark question, your answer is much more easier on the structure. So, your introduction is explain the judicial review. The purpose of basically it's the purpose of the judicial review. Then you go on whether or not he has satisfied with the criteria. So on the fact that Kumar was adversely affected by the decision made by the Minister of the Human Resources, these two requirements were satisfied so that he can make the application for judicial review. Now, the third part is you have to explain on the procedures. Then your Order 53, Rule 3, to get the leave, and then Rule 2 and Rule 4. And then you can make a conclusion. That is the 10 marks questions answer. Are we okay? Okay, I will stop my recording here because